American government, civil liberties. The United States Constitution explicitly protects a number of individual rights, many of them listed in the Bill of Rights, the first 10 amendments to the United States Constitution. The First Amendment, for example, identifies the freedom of speech and the freedom to assemble, while the Fourth through Eighth Amendments offer individual Americans a reliable shield, should they need it, against the abuses of government power. A central issue surrounding these rights is what they mean in practice, whether the government will honor its word and recognize these protections when it is inconvenient for them to do so. While it is quite common to discuss American civil rights, those individual protections government promises to its citizens, civil rights, American civil liberties represent an equally important set of protections, the freedom from government interference. Freedom from, freedom to. Take the case of Clarence Gideon. He was on trial in Florida in 1961 for allegedly breaking into a pool hall and stealing a small amount of money. Pool cue. Gideon was poor, and when he came up for trial, he asked the judge to provide him a lawyer. The judge refused. Gideon, an 8th grade dropout, was forced to defend himself in court. He lost his case. The Florida judge sentenced him to 5 years in prison, the maximum allowable for the crime of which he was accused. While in jail, Gideon read more about the law and decided to write a handwritten note to the United States Supreme Court appealing his conviction. The likelihood that the U.S. Supreme Court would respond to such a note among thousands was almost infinitesimal. The court hears fewer than 100 cases a year. To everyone's surprise, the Supreme Court decided to hear Gideon's case, one they only learned about from a handwritten note that was mailed to the court from a Florida state prison. They provided Gideon with an attorney, and when his case came before the Supreme Court, his attorney argued that the right to counsel or a lawyer is fundamental. How, he asked, can a poor individual like Gideon possibly win out in a trial against a trained district attorney? In rebutting that argument, the state of Florida said that its judges were fair-minded and wouldn't let anything but the evidence decide the outcome of a case. The Supreme Court disagreed with the state of Florida. It found the 14th Amendment's due process protection included the right to an attorney and at government expense if the accused was unable to afford one. It's the 14th Amendment, interpretation of the 14th Amendment. In his retrial in Florida, Gideon's lawyer expertly picked apart the state's case. He showed convincing evidence that its main witness had actually been part of the crime, acting as a lookout while his friends broke into the pool hall. The jury acquitted Gideon of the crime of which he was accused. In this case, Gideon versus Wainwright, the U.S. Supreme Court, which is a federal court, overturned the ruling of a state court. There was a time in American history where that type of decision was prohibited. It's because the Bill of Rights initially applied only to the national government. The First Amendment, for instance, says Congress shall make no law abridging the freedom of speech, the press, and so on. It doesn't say Congress and the state legislatures shall make no law, ... Thus, whereas Congress was bound by the Bill of Rights, state governments were initially not. Today, nearly all the rights of the Bill of Rights are protected from action not only by the federal government, but also by the state governments and even the local governments, which are agents of the state. The key to this change was the 14th Amendment, which was ratified after the Civil War to ensure equal rights of former slaves. It reads in part, no state shall deprive any person of life, liberty, or property. Life, liberty, or property. Without due process of law. Notice that the 14th Amendment refers to life, liberty, or property. It doesn't say that no state shall deprive any person of freedom of speech or any other specific right listed in the Bill of Rights. And it was not until 1925, nearly 6 decades after the 14th Amendment was ratified, that the Supreme Court began to interpret what was encompassed by life, liberty, or property. The breakthrough Supreme Court case was Gitlowe versus New York, which involved a man, Benjamin Gitlowe, who had been convicted of violating a New York state law aimed at silencing political anarchists, citizens who reject government. In its ruling, the Supreme Court held that state governments are not completely free to decide for themselves the speech they want to inhibit. The 14th Amendment's due process clause, said the court, protects free speech from action by the states as well. Once that precedent was set, the Supreme Court began to subsequently use the 14th Amendment to strike down state laws infringing on the remaining First Amendment rights, freedom of the press, religion, assembly, and the freedom to petition over the next dozen years. At this point, the court stopped, choosing not to litigate the other protections offered by the Bill of Rights from state action. Then, in the 1960s and early 70s, it resumed the process one by one, bringing most of the fair trial rights in the Bill of Rights into the 14th Amendment. The Gideon case, the right to an attorney, was one of those landmark rulings. Other rulings address such rights as the right to remain silent when questioned by police, the so-called Miranda rights, from the Miranda v. Arizona decision. This process, whereby rights contained in the Bill of Rights are extended to the state governments through the 14th Amendment, is called selective incorporation. Selective incorporation. It is selective because only particular rights in the Bill of Rights are given this protection. It's called incorporation because the process involves incorporating or bringing into legal interpretation of the 14th Amendment rights that are contained in the Bill of Rights, thus protecting them from state disarmament. In the Gideon case, for example, the Sixth Amendment right to an attorney, which protects citizens from action by the federal government, was incorporated into the interpretation of the 14th Amendment, thereby extending the right to an attorney to not only federal cases, but those involving state and local governments as well. Selective incorporation is one of the most important developments in the history of American civil liberties. Consider this question, indeed. Which level of government is more likely to violate your fundamental rights? Is it the federal government, or is it state and local governments that you interact with much more frequently? Well over 95% of the court cases alleging a violation of constitutional rights originate with state and local government. The main reason is that these officials have primary responsibility for policing and for maintaining public order, precisely the situations where citizens are most likely to actually come into conflict with government authorities. While driving on roads, walking on city sidewalks, shopping at the mall, or cheering on your favorite sports team, at a bar, or at the stadium. It's worth taking a moment to recognize the ways in which protected rights can be limited, for instance, if they cause harm to others. You have a right to free speech, but not to spread lies online in an attempt to harm another person's reputation. You could plead the First Amendment if you did that, but it wouldn't get you very far. You'd likely be found guilty of defamation, libel, or slander, depending on your method of communication. Libel meaning printing something that is you know to be false and injurious, or slander, saying something that you know to be false and injurious to another. In such case, you'd likely be ordered to pay for the damage you caused to the person's reputation. Rights can also be limited when they conflict with other rights. In that case, one's right must submit to the other. The First Amendment, for example, guarantees freedom of the press, whereas the Sixth Amendment guarantees a fair trial. At times, press coverage of a crime and trial can be so sensational that it jeopardizes the right of the accused to a fair trial. In some instances, though rare, judges, in an effort to protect the defendant's rights, have ordered reporters to stop reporting on a trial, suspended some First Amendment rights in order to protect some Sixth Amendment rights. There's a third situation in which rights can be limited, when they conflict with an overriding governmental interest such as national security or public safety. Take, for example, freedom of assembly, which gives citizens the right to stage political meetings, rallies, and demonstrations. But can citizens hold a rally at a time and place of their choosing? For example, can they go into the middle of a busy intersection at rush hour and begin to protest? The Supreme Court has said no, ruling that authorities can regulate the time and place of public gatherings for reasons of public order and safety, as long as they do so in an even-handed way without exercising viewpoint discrimination. It would be unlawful for a local government to allow one group, say PETA, the People for the Ethical Treatment of Animals, to hold a rally in a beautiful downtown park while forcing another group, say a squirrel hunters advocacy group, to rally in a rundown lot on the far edge of town far away from civilization. Keeping these examples in mind, let's see what these rights mean in practice, starting with the free expression rights. Free expression has long been viewed as the most basic of America's individual rights. Unless citizens can express themselves freely and disagree with the government, they cannot easily hold government officials accountable. It will not be long before they're stripped of other fundamental rights as well if they cannot speak out. Authoritarian governments understand this. One of the first actions upon seizing power is to silence political opponents under authoritarianism. Look to North Korea, Cuba, or Russia for contemporary examples. Since the American Revolution, Americans have never experienced that type of threat, but they have had their rights of free expression curtailed, especially during times of war. In 1917, soon after entering World War I, Congress passed the Espionage Act, which prohibited forms of dissent deemed harmful to the nation's war efforts. 2 years later, in Schneck versus the United States, the Supreme Court ruled on the Espionage Act. First time in the Supreme Court's history it had addressed the question of how far the government can go in restricting free expression. The case involved a socialist, someone who favors compulsory government solutions to address social problems, who had been convicted under the Espionage Act for distributing anti-war leaflets or handouts. The court upheld his conviction, saying Congress could restrict speech that presented a clear and present danger. In a famous passage from that decision, Justice Oliver Wendell Holmes wrote that free speech does not permit someone to yell "fire" in a crowded theater, thereby endangering those who would be harmed in the rush to the exits. The courts have spent more than 100 years since that decision further carving out what specific limits government can place on the individual's constitutionally protected First Amendment rights. In the early 20th century, the court tended to provide the government more and more leeway on First Amendment litigation, even arguing that expression that simply promoted a bad tendency could, in some instances, be curtailed by agents of the government. That rule was applied in a key 1951 case, Dennis v. United States, which took place at the height of fears about the growing threat of Soviet communism. The court upheld the convictions of 11 members of the U.S. Communist Party for advocating the violent overthrow of the U.S. government, even though they themselves had not engaged in any sort of violent activity. Then, in the late 1950s, the U.S. Supreme Court thankfully reversed course and began to take a fundamentally different approach to questions of free expression. The Supreme Court overturned the convictions of a different group of Communist Party members, arguing that they had the right to express themselves freely unless the government could demonstrate that their words were a direct and substantial threat to national security. Make sure you understand what I just said. The court did not say that free expression is always harmless. Instead, what the court has gradually concluded is that American society is in far greater danger if agents of the government assume the legal power to tell people what they can say and what they cannot say. Since that decision, a period which includes the Vietnam War, no American has been convicted by the court system solely for speaking out against a government policy. In the heat of the moment, protesters have been arrested unfairly and convicted for other reasons, such as assaulting a police officer, but no one has actually been convicted for what they've said. The imminent lawless action test. The imminent lawless action test is now the legal standard that the courts have applied in recent decades, specifically after the 1969 Brandenburg v. Ohio decision, which overturned the conviction of a member of the KKK or Ku Klux Klan. It holds that speech, to be unlawful, must seek to incite imminent lawless action and be likely to produce it. It is extremely rare for words alone to lead people into lawless behavior, and thus rare for a speaker to cross the line into speech unprotected by the Constitution. A society that protects civil liberties as much as ours is inclined to be a chaotic and cacophonous one. Justice Oliver Wendell Holmes famously emphasized the importance of toleration for dissident political speech in America. Quote, "If there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom for those thoughts that we hate." Similarly, according to the First Amendment, the U.S. news media are free to say nearly anything they want, which is critical if they are to play the critical role of government watchdog on behalf of the American people. The landmark case here is New York Times versus the United States, which arose when the New York Times obtained secret government documents showing that President Lyndon Johnson had lied to Congress and the American people about the war in Vietnam. The government tried to block publication of the so-called Pentagon Papers, but the Supreme Court sided with the New York Times, arguing, quote, "Any attempt by government to limit the press carries a heavy presumption against its constitutionality." In other words, the American press ought to be free to report on what it wants, establishing a freedom from prior restraint or government's efforts to stop the publication of factual materials. If it's not libel or slander, government cannot act preemptively to stop something from getting out. The Vietnam era gave rise to a number of other free speech cases, notably Tinker v. Des Moines Independent School District in 1965. There, a group of high school students favoring a truce in the early days of the Vietnam War decided to wear black armbands to school and were suspended for violating a hastily written school policy against such free expression. The Supreme Court found favor with these high school students, adding more clarity to our understanding of the power of the First Amendment, in this instance, even for people under the age of 18. The courts continue to wrestle with questions over free speech and education. Google bong hits for Jesus if you'd like to learn more about how the court continues to wrestle with these questions. During the same period that the Supreme Court was shifting its framing of the principle of free expression, it was also expanding Americans' fair trial protections. In addition to the Gideon decision, the court put limits on warrantless police searches. It upheld the defendant's right to trial by an impartial jury. It outlawed double jeopardy, a situation where a defendant is tried a second time for the same crime after being acquitted in the first trial. One of the best known of the 1960s era court decisions is Miranda v. Arizona. The case arose when Ernest Miranda confessed to kidnap and rape of a woman named Louis Ann Jameson. Miranda appealed his conviction on grounds police had not informed him of his constitutional rights to remain silent and to have an attorney. The Supreme Court agreed that Miranda's rights had been violated and stipulated that his confession should not be used as evidence in his retrial. Now, as it happens, police had plenty of other evidence of Miranda's guilt, and he was convicted and jailed a second time. The legacy of the 1960s decision is the now familiar Miranda warning, which police read to suspects at the time of arrest. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read to you? With these rights in mind, do you wish to speak to me? Let's look at one more issue, search and seizure, as a means of clarifying what Americans' fundamental liberties mean in practice, search and seizure. It was common under British rule for government officials to use general warrants to enforce their laws. These warrants were issued by judges in nature, broadly, and did not have specifics as to why they were being issued or what the arrest was being made for. A general warrant placed almost no limitations on the search or arresting authority of a soldier or sheriff granted a general warrant. This concept had become a serious problem when those in power issued general warrants to have their enemies arrested when no wrongdoing had been done. The Parliament of Great Britain reaffirmed the legality of these writs of assistance or general search warrants and gave customs officials broad powers to search houses and businesses for smuggled goods during the colonial anti-tax protests before the Revolution. This law was one of the key acts of Great Britain which led to the American Revolution and is the direct reason that the American founding fathers ensured that general warrants would be illegal in the United States by ratifying the Fourth Amendment to the Constitution in 1791. American warrants would need to be issued very narrowly after a judge had weighed the presented evidence so as to minimize the potential for a serious violation of individual rights. The Fourth Amendment to the United States Constitution reads, "The right of the people to be secure in their persons, homes, papers, and effects against unreasonable searches and seizures shall not be violated." Notice that the Fourth Amendment doesn't explain what's meant by unreasonable. So what's the difference? The difference between an unreasonable search and seizure that would violate the Constitution and a reasonable one, which would not violate the Constitution. What requires a warrant and what does not? Allow me to give an example of each type. Assume that police catch a suspect in the act of robbing a bank and then check the suspect's pockets for a firearm, a pistol. That would constitute a very reasonable search. In fact, I think everyone would agree the police would be derelict in their duty if they failed to see whether the suspect was actually armed. Such a search would not require a warrant from a judge to be conducted by that arresting officer. I compare that situation with police behavior in a 1962 case that became the Supreme Court's landmark ruling, Dapp v. Ohio, on what constitutes an unreasonable search. Police had come to Dalry Mapp's house without a warrant, believing that a suspect was hiding inside her house. When she objected, they handcuffed her. They didn't find the suspect, but they rummaged through her personal belongings anyway. In a box tucked away in the basement, they found pornographic material. She was convicted under Ohio's pornography laws and sentenced to prison. In 1961, the Supreme Court overturned her conviction. The court held that the constitutional protection against unreasonable search and seizure would be an empty promise if police could push their way into a person's home without a warrant and search high and low for something that might be incriminating. The Mapp decision involved what's called the Exclusionary Rule, the legal principle that evidence gathered by unconstitutional means cannot ordinarily be used against the accused during a trial. Uncovering such evidence is sometimes called fruit of the poisonous tree. Sure, you found something, but it's tainted. If agents of the government find evidence of something unlawful, and they have no legal basis to be searching for that, such evidence is inadmissible in court, no matter how incriminating. Now, keeping that distinction in mind, imagine for a moment that you're a Supreme Court justice having to issue an opinion on the following case. Assume that a man is arrested in the course of what appears to be a minor drug deal. Police confiscate his cell phone and begin searching through it. They find his phone number, obviously. They look up his address, they go to his house. There they find a significant amount of crack cocaine, cash, and unregistered firearms. Clearly, he's violating several federal laws. He is convicted. He appeals his conviction on the grounds that his constitutional protection against unreasonable search and seizure, protected by the Fourth Amendment, was violated by the police. How would you judge this case? Was the cell phone search reasonable and therefore lawful, or unreasonable and therefore unconstitutional? The situation I've just described is taken from a 2014 Supreme Court case, Riley v. California. It was a landmark case in that it marked the first time the court had ruled on police action involving an electronic device capable of storing personal information. In the 2014 ruling, which was decided by a unanimous vote of the 9 justices, they all agreed. The court held that the police search of the drug dealer's cell phone violated his constitutional protection against unreasonable search and seizure. The court reasoned that a cell phone, and by extension a computer or any similar device, is fundamentally different from a gun taken from a suspect's pocket at the time of the arrest. It's more like someone's house. A cell phone can hold a great amount of information, and allowing police to search through it without a warrant is not unlike allowing police to search a person's home or papers without a warrant, which is clearly unconstitutional. The court noted that police had a legal option. They could have gone to a judge to present evidence as to why they should be granted a warrant to search the cell phone in question. But in that case, it would be up to the judge, not the police, to decide whether the evidence was sufficient to allow the search. In the American constitutional system, judges alone have the power to issue warrants. Police can't do it on their own. The case illustrates the complexity of civil liberties issues when the balance between public safety and individual rights is at issue. Our society would not be safe if police were prohibited in all cases from acting immediately on what they see or what they were told. On the other hand, society would also not be a safe place if police could do as they pleased, even in the name of justice. You would not be safe in your home or your car or on the streets if police could stop and search you at will. That's the mark of a police state, not a free society. In the name of safety, Americans do occasionally lean toward favoring limits on personal liberty. For example, after the terror attacks of 9/11/2001. Such episodes inevitably end in widespread repudiation of the abandonment of our traditional values, since in America, individual liberty is our birthright.